All right, we're going to get started. Let me have your attention. We'll get started in just a couple of minutes. I've got two bills. There's a lot of interest in both bills. There is what we call the microchip bill. That's it. Get some copies of that for me. About enough for all the committee. The microchip bill is Senate Bill 235, and the other bill is Senate Bill 529, which is the anti-coercion bill. We've got a lot of people signed up, I know, for certainly the second bill. And we're going to take these in numerical order. I'm going to take the first bill, which is the Senator Pearson's Senate Bill 235 first. Is there anybody here on Senate Bill 235? 235. I know you are, Ms. Seltzer, and you are too. Okay. We're going to have a hearing on that part first so we can dispense with that, then go into 529. Due to the number of people we have, we're going to seek to accommodate everyone who would like to address the committee on Senate Bill 529. If you haven't signed up, you'll need to sign up on this sheet. I'd like to ask you to please leave your comments as to the point, and brevity would be a help so everyone has a chance and we're not here real late. I don't intend to try and cut off anybody, but if we're getting repetitive testimony, I may ask you just try and do what you can to bring your comments to a conclusion as soon as you can. And be sure we got a quorum now. We got 1, 2, 3, 4. Yes, we do. I'm going to call up Senate Bill 235 first. That's Senator Pearson's bill. And Representative Seltzer, you're here to speak on the bill for Senator Pearson. I believe you want to come up to the mic for us.
Thank you, Mr. Chairman.
Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. Appreciate the opportunity to speak on behalf of Senator Pearson for Senate Bill 235. Those who've been members of this committee for some time have seen this bill before. We actually passed this out 3 legislative sessions ago. It was formerly a House bill and has moved to the Senate. It received overwhelming support both in committee and on the floor of the Senate. And it actually passed out of this committee, but there were some other things that got in the way in the rules process, and it didn't get the floor for a vote 3 years ago. But Senate Bill 235 does address a problem that is an emerging issue, and I would just ask folks, we're working off of LC version 29407S. 29407S. I do have a package of read-along information I will refer to very briefly during the presentation. But if it pleases the committee, Mr. Chairman, I'd like to kind of talk generally about the bill.
We have this package, which is called the VeriChip.
It's
all right.
The VeriChip.
Everyone has that in their folder.
And if I could, Mr. Chairman, just orient the members of the committee to a couple of the handouts, and then I'll walk through the bill in some detail if it pleases the committee, and then certainly subject to questions.
All right.
The issue of microchipping is an issue that has been before legislatures for the past 6 or 7 years. The states of Wisconsin, California, and North Dakota have passed similar microchip protection acts. There are 5 other states that other than Georgia, that currently have propositions before them. And conceptually what it does is it recognizes that with the existence of FDA-approved microchips that can be implanted for a number of purposes, no one should be required against their will to be implanted with these technologies. Before I get into the details of the bill, I just kind of want to make a statement of principle that when you look at an individual's person and you look at what this bill seeks to address, we recognize as a culture that there's certain violations of people that no matter what their status is, just cross the line. When you think about prisoners, you think about folks, death row inmates. There's an outcry now about the treatment of folks on death row, and I think we recognize as a culture, and we have for the better part of a century, recognized that even the condemned have certain basic rights that can't be violated. And people ask me about this. They say, well, shouldn't we be able to microchip, if we're microchipping pets, shouldn't we be able to microchip prisoners? Shouldn't we be able to microchip folks that are under the supervision of the probation program? And before we walk through the bill, I just wanted to, at the 20,000-foot level, kind of highlight there's certain things that under no circumstances do we as a culture do to people. That if you take someone that's 10 days away from being executed through our judicial system, having exhausted all appeals, even the condemned, there's things we can't do to them. You can't break into their cell block and take a billy club and beat their face in just because they're condemned. You can't break in and violate someone's person sexually just because they're in the detention of the state, even if they're condemned. There's certain basic things you just can't do to people. And what this bill seeks to do at a very high level, before we get into the weeds, is to recognize there's certain violations that the state, that employers, that people who have a position of power over another just shouldn't be able to do in principle against a person's will. And it's to that principle that we look at and we see the emerging technologies that allow household pets to be chipped, to be tracked with GPS devices. We see FDA-approved products. The one I've got before here is a VeriChip. It was approved by the FDA back in 2002. We've got 8 hospitals in Atlanta that have, none to our knowledge have implemented this, but have gone through the agreement process to be able to use these on a voluntary basis. You see, if you look at the materials, I've got some language that deals with warranties, how there's not strong legal protections around them. Handout 2 deals with a medic alert bracelet. That there are other technologies that accomplish everything that would need to be, frankly, accomplished with this technology.
Yeah. And let me just, not to cut you off, but we had hearings earlier this year, this session, dealing with the previous bill. A couple of things come to mind. The type of microchipping you're concerned about, is it not ones that will be placed under the skin? And I use that as a way of defining it, as opposed if I had a bracelet and I'm required to wear this bracelet as a part of being a con.
Right.
Out on probation, they say, wear this bracelet, it's got a microchip in it where we can track you all the time. We do that now with bracelets on the ankle.
It maintains that status quo. This does not address any attached bracelets or tracking devices we currently use.
It's under the skin.
It's under the skin or applied permanently to the skin, like a tattoo-like permanent application or an under-the-skin subdermal application.
Would it not? Well, if you say tattoo-like, how would you mean, on the surface of the skin?
And I'll speak to that, Mr. Chairman. There's actually technologies now that allow a special ink to be used as a tattoo that, in essence, is a 2D barcode on a person that can be interrogated from a distance and read.
Okay.
And I was going to talk. That's within the definition of microchip. So, again, Mr. Chairman, I don't want to spend too much time going through the background. I think many of us have heard about some of the technologies that exist. What this bill seeks to address is the proposition that as technologies emerge and capabilities exist, the potential for violation exists. If you look at our laws back in the 70s and 80s, back before DNA was used broadly by with our criminal system, there were some protections put in place for those that carry insurance. Before there was any contemplation that any existing company would use DNA profiling information to limit someone's access to life insurance or health insurance, a law was put in the books back in the early 1980s that limited the ability to use DNA technology to deny or accept someone for health insurance. Was that being done in the early 1980s? Absolutely not. But was the science being brought to bear in a way that the potential for that existed that gave this General Assembly concern that someone's DNA profile could be analyzed and used as a means of screening someone out for health insurance coverage? This General Assembly has acted in similar ways when emerging technologies presented themselves in a proactive way before problems have presented themselves, and that's simply what Senate Bill 235 seeks to do with microchips. Mr. Chairman, if we could, I'll walk through. It's a relatively simple bill. Most of the bill, frankly, lies on page 1, section 2 in the definitions. If you can skip down, the operative part of the bill is on line 24, and it mirrors the language from the Wisconsin statute. It says no person shall be required to be implanted with a microchip. That's the operative language. As we talked about before, though, and as I mentioned, what I think we may spend the most time on is the definition section that talks through what implantation means, what microchip means, what person means, and in this context, what require means. And Mr. Chairman, I think that's going to be the substance of the bill. To the chairman's question, what is a microchip? That'll be addressed on lines 16 through 18. Before we say that, though, I wanted to walk through lines 14, and 15 that deals with the definition of implant. Implant includes any means intended to introduce a microchip internally, beneath the skin, or applied to the skin of a person. So the bracelets that we have now in our current context for probationers don't apply here. It's a subdermal, deep body, or a permanent application to the skin of a person. Those are the only technologies that apply within the definition of implantation. Microchip, again, as you see, means any microdevice, sensor, transmitter, mechanism, electronically readable marking, or nanotechnology that is passively or actively capable of transmitting or receiving information. This does not apply to pacemakers. It came up 3 years ago. The committee was concerned about pacemaker devices that are implanted. It specifically excludes pacemaker technologies. This is simply the passive or active chip technologies that we see available to us technologically today. Person, any individual, irrespective of age, legal status, or legal capacity. One thing this bill seeks to address is the notion that certain decisions we've held out as a culture are inherently adult decisions. When you talk about an implanted technology, these are technologies that could be inside of a person, certainly as proposed in the FDA application and approval for permanently or for multiple years. The notion that a family could decide that their 16-year-old high schooler was getting a little wild and they wanted to be able to implant them with a microchip to be able to track their high schooler has been one of the issues that the other states in addressing this have sought to address, and is clearly in the center of the scope of Senate Bill 235. It's the proposal of the author and the meaning of 235 that the accepting of a microchip is inherently an adult decision, that implanting 16-year-olds against their will is akin to doing other things to minors that are illegal, and that what this in essence says is that adults can consent to this, but the notion that someone's speaking on behalf of another person legally to force them to be chipped is problematic based on the principles we outlined earlier about there's certain things we just don't allow people to do in our culture in terms of violations of another person's private space. Lastly, is intended to include physical violence, threat, intimidation, or the conditioning of any private or public benefit. With advancing technology, you can see the potential if, for example, let's say a trucking company decided that, if we were to plant our drivers with chips, and there's extensive research in this field, both for identifying, pandemic flu and pandemic viral infections. There's technology that's being explored to be able to introduce inside of people to tell if they've been fallen subject to a pandemic virus of some kind. There's also technology that allows an implanted chip to track people's biometric conditions, i.e. blood alcohol content, drug content, and the like. The concern is if one were to have a trucking company, for example, that were to say, I want to be able to guarantee my drivers are drug-free. I want to be able to guarantee that my drivers are not driving drunk. There's currently no provision in Georgia as a right-to-work state that an employer that would prevent an employer from going to an employee and saying, we pay awfully good in our trucking company, and we treat you guys well. We give you a good Christmas bonus. We have a great benefits package. But if you're going to work for us, we want to be able to guarantee our insurance company, our folks are drug-free when they're on the road and when they're driving. We want you to take this little old chip, and we'll be able to check from our laptop computer and make sure that you're not driving drunk. Does that exist in 2010? No. That's not a current problem facing us, but the potential exists technologically for those kinds of things, and conditioning a private benefit in a right-to-work state on someone accepting an implantation of a technology like this, in the belief of the author, and certainly in my belief, is a violation of the kinds of rights we're trying to protect here. And that's why the conditioning of any public or private benefit is contemplated in the restrictions of requirement. Again, the operative part of the bill is line 24, mirroring the Wisconsin language that no one shall be required to be implanted with a microchip. And the second page simply defines it as a misdemeanor, as it is in other states, and gives someone a private right of action to pursue damages. Lastly, lines 29 to 30 define the legal accepted consenting implantation of a microchip, which is still going to be fully legal, to be defined as a medical act, not to be done by friends or buddies, but only by licensed physicians and subject to the authority of the Georgia Composite Medical Board. That's the bill, Mr. Chairman.
Gotcha. Questions of the presenter? Any questions? We have, I believe, Mr. Weldon.
Mr. Setzler, thank you. Thank you, Mr. Chairman. You, when you started your presentation, you stated that there are certain inalienable rights that even those convicted of crimes, even the most heinous crimes, have. And you said you can't break into a jail cell and beat them. You can't violate someone sexually just because they're a convict. When I think of inalienable rights, I think of jury trial, right to a trial by jury of peers. I think of the right to face your accusers. And the reason I believe that we have those protections is not to protect so much those that are accused, but those who aren't accused. I think I agree with you that you can't break into someone's jail cell or prison cell and do harm to them personally. But I'm not sure I'm persuaded that someone convicted of a crime, or particularly a violent crime, should have this privilege. You know, everyone that's an innocent or someone who's not convicted of a crime has many freedoms. They can walk about. They can travel the United States of America, and they can go anywhere in the state of Georgia. Many other rights, but those persons that are convicted of crimes, who have either pled guilty or been found guilty by a judge or a jury of their peers, that's been chosen by the laws of the state of Georgia, they have given up rights by an act that they performed. And it seems to me that a prisoner convicted of a crime, either by plea or by trial, has given up many of his rights to privacy. They don't have right to privacy in anything they have. And it seems to me that this would be one measure we could take to track in the event of an escape. What about those people that could be harmed, or those victims that could be harmed? Let's say we have a violent offender that's out there that gets loose, and we could track them with a chip almost instantaneously.
I appreciate the question. I'll ask you this. What's your opinion of the current system where people that are out on probation have ankles, that they have the bracelets put on them, that allow them to be tracked, they're locked, it notifies the authorities if that seal's ever broken? Do you have confidence in that current system?
Well, the way this works in this committee is we get to ask the questions and you get to answer them. So if you would answer my question. Okay,
I'll attempt to answer your question by sort of answering my own question. I would submit to you, isn't it true, that the current system that allows us to apply bracelets, ankle bracelets to folks to be tracked, is a functioning technology. The concerns of someone removing it from themselves are mitigated and frankly addressed using the existing technologies. The notion that an implanted microchip that's under someone's subdermal fat layer on their tricep is frankly no more secure on them than the ankle bracelet. In fact, there's an argument that it's easier to pull out a microchip than it would be to detach an ankle bracelet, recognizing as soon as the seal's broken, it notifies the authorities that it's been broken. I would submit to you that to address your concerns, and I think they're valid concerns, it's fair discussion. But when you really get into this and you look at the implementation of the technologies, a microchip technology does nothing more for us in terms of security of folks that have been released from our custody that the existing latch-on technology doesn't provide us. And that, frankly, when you really get into it, like the ability to remove a microchip versus the ability to break a seal and that be notified, frankly, you could make the case that the existing technology is more secure.
If I may, Mr.
Yes,
Chairman. So
Follow up.
the technology we have now is no better than the microchip, and the microchip's no better than what we have now.
With respect to tracking, I would argue that the current technology we have now is more sophisticated than a microchip.
We're going to have to leave that door closed. I see Senator Pearson, you come on in this bill, but we're keeping that door. We got really more people than they permitted in this room at this time. I think we have chairs for all that are really permitted as a practical matter, and I think we need to leave the door closed because the noise, I know, is a problem for the people sitting over there on that side to hear the testimonies. Senator Pearson? Senator Pearson, you want to come in and have a seat? This is your bill?
Just passing House bills out of economic development, Mr. Chairman.
Oh, wonderful. None of mine there, I don't
What
believe.
senators should be doing this time of
That's
year.
right.
Yes, sir. Yes, sir.
Glad to see you, sir. We're in the process of considering Senate Bill 235. Go ahead, you finishing up?
Thank you, Mr. Chairman. It just seems to me that the rights of privacy and other rights, which some of them will have been extinguished, when somebody's accused of a crime, they face their accusers, they have the right to privacy, but they give that up because of their action. It's not because of negligence. It's a proof beyond a reasonable doubt that someone has committed a crime. And a jury of their peers, generally speaking, in a criminal setting, could be a bench trial, or it could be a plea where they acknowledge that they have done the things they've done. And they do that for a purpose. Murderers, someone who murders someone as someone else, they enter a plea so they can avoid the death penalty. Many times that happens.
I'm going to leave you to ask questions if you would right now.
And of course, yes, sir. Thank you, Mr. Chairman. It seems to me that this is a right of privacy that has been willfully, intentionally, and purposefully taken and relinquished because of their intentional act. And could you just reflect on how that's going to be, how using the technology we have today will enhance our ability to track these folks without the
Sure. I mean, I don't think anyone in the committee, or certainly myself, the author, dispute the notion that when one's convicted of a crime, particularly a felony, that they lose significant rights. That's not in question here. The question really is, I think, is there a compelling interest of the state that the microchip really addresses that nothing else can address? I mean, I think you would agree that the implantation of a chip inside of a person is a very significant. If it were a person that weren't convicted of a felony, and the state was contemplating implanting people, someone raising the objection that, wait a minute, this is a violation of my person, it would be a very significant violation of one's person. Would you not agree, sir?
Mm-hmm.
Okay. So recognizing it's a very significant violation of one's person, even if it's a convicted felon, it's a significant violation. The question is the state's interest outweigh that? And if there's no other way to address the concerns of the state for bringing the person to justice, then you could, to that extent, you can make the argument. But I'm not sure that a person that's locked away at a maximum security prison is any more secure with a microchip than without. And if someone is satisfied the concerns of the system so that they're being paroled and let out, then they've met a standard of conduct that the state's confident they can begin to loose some of those reins on them. And I would argue with you that the existing technology that allows you to put a bracelet on someone's ankle that's been seen fit to be put on parole, or in a case of probation, if that's appropriate, as the case may be, we've got existing technology that addresses the state's interest in the exact same way a microchip can, but without that very significant violation that you recognize is really a big deal. And that's the concern, is the existing technology is equal to, or in some cases better than, addressing the state's interest without the violation that this bill is concerned with.
Ms. Dobbs, you have your button pushed.
Yes, thank you, Mr. Chairman. My question goes to
I think I thought I had. There we
the
go.
definition on line 19, person, and the words legal capacity. And I was just trying to think of, in addition to the state's interest in implanting someone in the criminal justice arena, what about individuals who have a problem with the mental capacity, those who have Alzheimer's? I have no idea of looking into the future and just seeing what type of technology might be invented to help with just monitoring and keeping track of those who have dementia.
Sure.
How does this bill affect those individuals?
Important question. We've got in fact, I included in the packet, in fact, it's item 2 here. It talks about the medical alert bracelets. And medical alert bracelets actually a product almost identical to Verichip. It's just, it's a metallic bracelet that can be put on someone's ankle, someone's wrist, in a way that's intended to be unobtrusive, but again, addresses the same concern. If you've got a senior citizen that is let's take a senior citizen, for example, that's in a state of dementia that they're not going to dispute something, then nothing this bill contemplates the notion that an ad litem can't make the decision for them to use technology. However, if they're a person that's kind of lapsing in and out of dementia, that made it clear to their kids, I don't want a microchip, I don't want that done to me, there's an alternative technology that allows tracking of people. In fact, these things are used today without the forced implantation. I think that the thinking here is it respectful of people's dignity if you've got a senior that says, I don't want this, my kids think I'm crazy, but I know what that thing is, and I don't want that in me. Is it a compelling enough interest to force that person to take the chip, or because there are alternate technologies, should we provide that person the protections as long as they can put up some kind of opposition? And this bill contemplates if there's opposition, recognizing there's other technologies to address it, that forced implantation can't happen. If there's no opposition because the person's is given over to dementia enough, it's not going to be in conflict with the bill.
Chair recognizes Mr. Bruce. Bruce.
It seems that your objection is not to tracking people. The objection is to just sticking them, basically, and putting something in them. Is that correct?
Well, I think it's both. I mean, I've got, when I was a lieutenant in the Army, I got stuck about 10 or 12 times a year. Every time you went overseas, they'd stick you and put something else inside of you, typically a chemical of some kind to keep you from coming down with malaria and other things. It's not just the sticking piece, but it is the notion of what are you being stuck with, what's being put inside of you. I've got metallic fillings in my teeth. I don't object to those because someone can't track me with the metallic fillings. People have pacemakers. They don't object to those because they save their lives. But when you're being implanted with a thing that allows you to be tracked, when you're being implanted with a thing that allows someone to track your blood alcohol content, when you're being implanted with something that allows people to scan you with interrogate a chip inside of you and find out information about you, I think that is a profoundly different step than the metallic fillings in my teeth.
Okay, so you object to both, because listening to you talk, it sounded like you weren't objecting to both. That's why I was asking the question.
I think the idea of the implanted microchip is the combination of it being in your body against your will and it having some effect on your personal privacy.
And one last thing, because there are certain times when we are injected with things. I remember when I was growing up, you may not be old enough, but we had to have shots and different things for various diseases that we didn't have a choice in. And some of us still walk around with a little burn on your arm to show that you had those vaccinations and things like that. Does this deal with that at all?
Well, what this addresses is, to take your polio example and fast forward that to the 21st century. If there was a belief that, much like polio was a concern back in the 50s, 60s, and 70s and earlier, that all kids had to get it. If there was that kind of concern about kids being lost, that we would want to implant every child with a microchip that enrolls in public schools, this bill seeks to absolutely address that. This bill seeks to say, thou shalt not, a school board or shall not pass a law that requires kids to be implanted. I'm not implying that's about to happen. That sounds fanciful, but it's the notion that a microchip implant is a very, very significant thing. I would argue it's way more intrusive than a vaccine.
Thank you. Any other questions? Chair has a couple of points I want to ask about, and that is, you mentioned children. If I, as a parent, have a child that I want to say, for security reasons, wish to put a microchip in my child till they reach a certain age, as I read the bill, this would be prohibited.
Yes, Mr. Chairman, it is.
And it also involves, I guess, what we call a operative procedure, because you have a breaking of the skin. And as I understand from doctors, if a person is having something done against their will, the doctors will not, for instance, perform a surgical procedure. So you're not going to be able to get somebody as a surgeon anyway, a doctor, to this, as far as breaking the skin to do the implant, correct? Against their will.
Medically, that's correct. I think the concern, Mr. Chairman, if I could, is if you were accepted as a partner in a law firm or an officer of a large corporation, and one of the conditions in this right-to-work state is, congratulations, Mr. Willard, you now have the keys to the kingdom. You're now an executive vice president. But one little detail, we want to make sure we address. You've got the responsibility of a $2 billion corporation at your hands. We want you to take this microchip so we can make sure you're not involved in any at-risk behavior.
All right.
In a right-to-work state, you'd be forced to consent to that. And you'd go to your doctor and say, hey, I need to get this microchip implanted in me. And the doctor would say, okay, and he'd do it. But what this bill addresses is, should someone be forced to consent to something like
against
that?
someone's required, against their will.
That's correct. So,
Okay.
in that case, the physician regulating it wouldn't be applicable, because you'd go to the physician and say, well, I want to do this, and to the physician's knowledge, you're satisfied with it. But what this would seek to regulate is that no employer could make you do that.
Okay. Mr. Lindsay.
Just a couple quick questions, and I appreciate you bringing this bill, and appreciate you brought it a few years ago. And you raised the fact that several other states had already addressed this. How many other states had already?
Yes, all phones will be put on either vibrate or turned off.
Wisconsin,
Here,
North
please.
Dakota,
If you
California.
haven't done so, do so, please.
Any of those three have any exceptions, or are they pretty much along the lines of your bill?
Wisconsin's language is almost exactly what line 24 is.
Yeah.
It doesn't go into the definitions.
Yeah.
We saw fit, rather than passing something through that was that short and simple, that we
Sure.
flesh out some more at the behest of this committee.
Yeah.
Flesh out some more details. North Dakota's passed theirs much more recently. I can't speak with great detail on those. I will say some of the language in the California statute incorporated some of the language we initially started with.
Yeah.
We were working before they were, but I'm not an expert at their legislation.
I'm just sort of curious. What you said? What did California have?
We could tell some of the language. I've looked through it. I noticed some of the same wording, but with respect to the specific provisions, I'm not an expert on their statutes.
Okay, but no one has come up with some of the exceptions that you've heard here. Is that what you're telling me?
I'm not able to speak to
Okay.
that.
Just sort of curious.
I can tell you, I know for a fact Wisconsin's is very similar. It says no person shall be required to be implanted with a microchip.
Okay, thank you.
Thank you. Mr. Jacobs.
Mr. Satzler, there's a substitute that was handed around. I don't know if have you
Not seen it.
someone get a copy? I just wanted to.
Take it down to
As I understand it, I mean, and I'm not the one presenting the substitute. I just, as I understand it, this is modeled after another state's law, which is actually just stated in a much simpler and more straightforward way than the definitions and whatnot that are in the current version of Senate Bill 235. I was asking, or I'd like to ask you to comment on this version of the bill and see what your thoughts are about it.
It doesn't take a long time to read this. For those of you who are listening, no person the substitute simply says no person shall require an individual to have an inserted into such individual's body a microchip containing a radio frequency identification device. Makes it a misdemeanor. I think my chief concern with this would be the first concern would be containing a radio frequency identification device. As I outlined, the definition of microchip was broader in what we defined, again, to address the technologies that could be a mechanism that might not run on RFID technology, a special ink that's tattooed, as is available today. I think if you're trying to address what the substitute's trying to address, I think containing a radio frequency identification device, those last few words make it problematic. But other than that, I think if I were trying to perfect the substitute, I would just end after the word microchip on line 11.
All right. And what if we were to import the definition from the bill, from the as passed the Senate version of the bill into this version? It'd still be a simpler bill.
I think that'd be an even better way to accomplish this purpose.
Right.
Absolutely.
All right. Thank you. Senator, would you like to comment, since I know you had a late arrival?
Just glad to be here, Mr. Chairman, and obviously the representative that presented the bill knows more of this bill than I do, and we're glad to have helped him in the Senate side, and would certainly yield to his experience and expertise in this area. I think I would add one thing that came out, as you can see, the Senate bill differed somewhat from as it came over, originally was introduced in the House, and that is that our Chairman Wiles had made a point on the situation where you had someone convicted of a crime and part of the penalty was some type of a tracking device or something of this sort, that if it was to be intended to use something under the skin versus external, like a bracelet or ID badge, whatever, that one of the conditions potentially for parole could be, okay, you can get out, this spring if you take this implant. If not, it may be next spring. So when you get past the voluntary part, there is options around that when someone has, broken the law, and this is part of the judge's decision to track the people in any way. So again, I think it showed the ability to deal with it and still be respectful of persons, which the Constitution requires us to be.
It sounds like what you're saying, though, where a person may or may not get out on parole early, depending on whether or not to take the chip.
That's
It's
correct.
a decision they make.
That's correct. They've
So
made
not
that
being
decision.
required, it's going to be their decision to decide whether they want it or not.
Exactly.
Okay. Thank you. Yes, ma'am, Ms. Stevenson.
Thank you, Mr. Chair. Senator, thank you. To your explanation of not being required, what is the difference in that example than the required definition on lines 20 to 23, the conditioning of any private or public benefit, including employment promotion? To me, that's very similar to the analogy that was used in employment, the parole example. What is the difference that is not required as a condition of parole?
I guess I'm not following the question.
Okay.
Representative.
You said what you considered voluntary was an early parole, but that is what I heard, a requirement for the early parole. I don't see it in this bill, but when you said that as an example that could be used, it made me think that it was not harmonized with the definition of what I read as required. Because it says, or any means that causes a person to acquiesce to implementation when he or she otherwise would not.
Well, again, there'd be something of benefit here, and it would be their decision. And again, I'm not necessarily saying I agree with that. I'm just bringing out what our chairman brought up in the committee, because there was a question of when, and it may have been addressed here earlier, of when it is a part of a sentence for someone, or part of a parole, is how do you deal with it? Because, obviously, the businesses that invested in the research, the patents, FDA approvals and all that, their goal ultimately is to market these in any way that they can, recoup their cost and make a profit. So we pretty well can ascertain that it's a matter of when, not if, they're going to be marketed to all types of public service and penal institution purposes, along with dogs, pets, kids, elderly, all that. So I just brought that up as something that was discussed in our committee as a possible alternative.
Thank you, Senator.
Thank you. All right, we have no more questions of the committee for the presenters. Do we have anyone in the audience who would like to comment on Senate Bill 235? Yes, ma'am. Would you want to come around, please, and take a seat so you can address the committee? And give us your name, and if you're representing a body or a group of people, association, tell us who that is.
Thank you, Mr. Chairman. I do represent many people, and I think some of them have introduced themselves to you folks this week in the last 10 days. But I'm a volunteer, and the people, I have about 10 different organizations that asked me to be their spokesman today. And one of the major things that I have not heard discussed is the medical problems that could arise with this microchip. And the people have not been implanted long enough for enough research to be done to be able to explain what might take place in the body of a human being. But animals have been researched, and animals have had some problems with cancer and other drifting of the microchip throughout their bodies. So there are medical problems attached to this. And one of the gentlemen in the Sloan Kettering Cancer Research Hospital in New York said, as a doctor, he said, after seeing the research, I would not have a microchip implanted in one of my family or in myself because of the dangers.
Would you give us your name, please?
Sue Ella Deadweiler, and I apologize.
That's all right. Thank you, Ms. Deadweiler. Glad you're with us today. Any questions of Ms. Deadweiler? Thank you, ma'am. Does anyone else wish to speak to the committee on this piece, this legislation?
Pardon me. Yes, ma'am.
Good afternoon. Give us your name and who you represent, please, ma'am.
My name is Kathleen Gary, and I'm a resident of DeKalb County, and I'm also one of the people in Georgia who has a microchip. And I've been talking to the different legislators and trying to get help in trying to outlaw this the implants. I want to speak particularly on the medical issue of the microchip that she mentioned. And I just got a few things. Microchips, they infringe on issues that are fundamental to our very existence. That our rights to privacy, our rights to body integrity, the right to say no to foreign objects being put in our bodies, specifically the right to refuse microchips being put in our bodies by the government, or anyone else, the right not to be tortured in our homes by these microchips being scanned by electronic devices that is happening, and to activate these microchips, the right to work without being tortured by co-workers who are activating these microchips by using their cell phones and other electronic devices, the right to just live, work, worship, attend schools, attend church services without being further torture from these microchips. It's actually torture. It's just not just a little implant that you put in. You're actually tortured by these microchips. When they are scanned, they cause the body all kind of problems. Microchips are like little beepers. And just imagine, if you will, having a beeper in your rectum, a genital area, and the most sensitive area of your body, and your beeper number is displayed on billboards throughout the city, all done without your permission, with an award available for each caller. Hundreds of people calling you, blowing up your beeper, vibrating it in your flesh, invading your privacy rights to your own body. You're followed and tortured everywhere you go. You travel all over town trying to get somebody to help you get it out, and but instead, you feel the shocking pains from the tip of your spine to the bottom of your feet. It's like a grounding effect. Blurred vision, headaches, stomach pains, cramps, muscle spasms, uncontrolled blood pressure issues on 2 or 3 blood pressure pills, fatigue, stinging and burning skin, loss of concentration, ringing in your ears, heat sensation to the skin from the scanning devices, frictions of the vibrations that's going on with somebody calling and dialing, and this thing is working constantly in your flesh. It's torture every single day. And every time you try to find help, you go to doctors, and their hands are tied from giving you the proper medical treatment that you need and deserve.
Thank you, ma'am. I think we got a question from one of the committee members. Ms. Oliver, is it yours? Or no. Who was it? Someone on the end? Mr. Weldon? Thank you.
Ma'am, did you say you have a microchip?
Yes, I do. And this microchip is put in my vaginal and rectum area. And I have been dealing with rape and sexual assault with them trying to take it out. When you try to make people accountable for what they have done to you, then they go to any extremes in trying to get it removed. And these are the issues that anyone, not just me, but any person who wants to make people accountable for the implant that they put in them, they will deal with all kind of harassment, all kind of torture as a result of you speaking up about it.
Let me get him going. Do you want to ask me further? Anything further from any members of the committee? Ms. Garvey? Is it Ms. Garvey? Is that right? Did I have her name right? Gary? Ms. Gary, is it?
Yeah, Ms. Gary.
Excuse me. Okay. Sorry, Ms. Gary.
And that one other thing, you mentioned, gentlemen, you mentioned about the implant and being put in criminals. I feel like our right to, this deals with our right to our body integrity. This is a God-given right. When we are born, we are naked. We only have our bodies.
Let me ask, hold your comments, we can get some questions to you.
Okay.
Mr. Maddox?
Thank you, Mr. Chairman. I guess I may have just missed it. I was just curious. You're saying this was an involuntary implant?
Involuntary, yes. I am in the U.S. appeal court right now. This case has been going on for the last 8 years, and we're trying to get some help in trying to get this outlawed and get some justice in that. I feel like Senate Bill 235 is on the right side of justice. This is an issue that is
Let me ask you, hold your
ongoing.
comments, we'll get the questions done.
Okay.
Anything further, Mr. Maddox?
That's all.
All right. Anything further from the committee? Let me ask Ms. Gary this. Who implanted this in you?
I
that's a-
feel like mine is...
You don't know who did it?
Yes. I'm one of the federal government research with this microchip.
And who in the federal government is implanting
And
you?
this is the Department of Defense.
All right.
And this is the court case that is pending before the U.S. Appeal Court.
All right. Thank you, ma'am. Anyone else wish to address the committee that hasn't had a chance to speak? If not, we will close all public input. Yes, ma'am. You'll have to come around and let you take a seat here.
I'm
Yes, ma'am.
Margene Burt, Alpharetta, Georgia. I have several people from an organization up there that's standing here. They might like to raise their hands that are opposed to it.
Put your hand, put the mic down where they can hear you a little better now.
I said that there's several other people that are with me here today that might like to raise their hands that are opposed to this bill. And we're from an organization in North Fulton. But individually, I would like to say that I feel like that it's a right taken from us that is given, inalienable right. And I have heard of people having cancer from the chip and also from it moving around in their bodies and don't know what the extent of it might be. And also being a Bible scholar, I think it sounds very much like a chapter or two in the book of Revelation, 13th and 14th chapters in Revelation. And I think it could be leading up to that, which is something that happens in the last days called the mark of the beast. I think it could be a forerunner of that. And I just don't think this right should be taken away from us. I don't even think chips should be put in, period, but certainly not to people that are opposed to them.
Thank you, ma'am. Any
Thank
questions of the committee members? If not, we appreciate you being here with us today, Ms. Bird. Oh, do you want to ask a question?
No, sir.
Yes, sir.
I'm wanting to make a motion.
All right, we'll close off public input. We don't have questions asked of us. You can present if you want to come speak to the committee. You give us your name and who you represent.
I represent myself. My name is Terry Green. I'm from Woodstock, Georgia, and I'm here for the second issue that's going to be brought up.
Yes, ma'am.
But in hearing this discussion, I think you're talking about three different issues. You went from rebellious children who were 13 years old, you talked about pets, you talked about criminals, and you talked about the elderly who suffer with dementia. To me, if you're going to have a bill like that, they should be 4 different bills because you're talking about 4 different aspects of life. My husband has taught in a nursing home for 9 years in Roswell at Mansell. Those people there who have dementia, Alzheimer, and live in assisted living, wear a bracelet. I mean, I don't know why we're concerned with where the private sector is already taking care of the elderly on their own, and how implanting something in an elderly person as opposed to a rebellious 16-year-old, as opposed to a criminal who may be on death row, to me that's like discussing the 2,300-page health care bill and the aspects of it.
All right.
I'm just trying to understand.
Yes,
it seems like it's run the gamut of a dog to an adult with Alzheimer's. And
Thank you.
where's the middle of the road that it makes sense?
Thank you, ma'am. Any questions of the presenter? Thank you for comments. Anyone else wish to address the committee? If not, the chair will close all further input. The bill is now in the breast of the committee. Is there any discussion on the bill, first of all? If not, the chair will entertain a motion. Hatfield?
Yes, Mr. Chairman, on LC 294070S, parentheses SCS, I would move do pass.
Have a motion do pass. Do we have a second? Do we not have a second?
I'll give it a second.
We have a second. All right. We have a motion, a second. Motion is do pass on LC 294070. There you go. As the Senate bill presented to the committee. And do we have any discussion on the motion? Do we have any amendments? No amendments. The chair will call for the question. All in favor of do pass on Senate Bill 235 signify by saying aye.
Aye.
Opposed, like sign. Chair rules the bill has a do pass on the motion.
Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman.
We'll next take up Senate Bill 529. And this is also Senator Pearson's bill. Let me say from the outset we have a long list of persons who would like to address the committee. The chairs will exercise It's prerogative on the individual speaking. I know I have several people here. I don't have them identified for both pros and cons to the measure who are here as either scholars legally or medical persons. I may take those first, realizing your time is relevant as far as getting back. I'll let we will then take the listing of people who wish to speak on the bill. There's quite a list of them. I'll ask you to try and keep your comments succinct and to the point on the issue if it hasn't already been addressed. Senator Pearson, would you like to present the bill?
If it wouldn't be out of order for your committee, I would respectfully ask that my colleague here, Representative Setzer, present the bill, and my presence is needed in Senate insurance to pass House bills, and I would be back directly upon completion of that task.
Will do.
Thank you, sir.
Introduce who you have with you.
Mr. Chairman, appreciate the opportunity to present Senate Bill 529 on behalf of Senator Pearson. I have with me, and again, before the committee, we should be looking at LC version 294296 ERS, 294296 ERS as passed the Senate.
And let me add, since I did not say it earlier, this is going to be for a hearing today only. There will not be action taken on the bill. We may conduct a further hearing, but there will at least be another time for the committee to consider action on the bill after today.
Thank you,
Go
Mr.
ahead.
Chairman. I have with me Jonathan Crumley from Little Crumley and Chambliss. He's the counsel for the Georgia Right to Life. He's been heavily involved with a team of attorneys drafting what's before you as SB 529. And if it pleases the chairman, I'd like to have Mr. Crumley help me make the initial presentation of the bill today if we could.
Fine.
Again, you should also have in your package, before we walk through the bill, should have a summary of items. I'll speak to some of those, Mr. Chairman, if it's okay with you. Should have in your packet 15 pages or so of items that we'll refer to as we make our presentation. Mr. Chairman, again, if it pleases the committee, I'd like to kind of walk through a couple background items that I think is important as context for the discussion of SB 529. Then if it pleases the committee, we'll walk through kind of line by line the bill, explaining the way the bill functions, and then certainly subject to questions of the committee. I do have, Mr. Chairman, two folks I'd like to speak today. I'd certainly in no way looking to limit the testimony of the public. I do have two people I'd like to be able to identify and speak, and when the time is appropriate, on behalf of the bill, Mr. Chairman. There's been some discussion in the media about SB 529, but 529 seeks to, in essence, do one thing. It seeks to address the existing laws in our state regarding criminal abortion, and in addressing them and in performing that function, ensure that physicians licensed by the state of Georgia to practice medicine don't operate in bad faith, that licensed physicians don't operate in bad faith, and that there's no violation of rights of established protected classes that have been protected for more than 5 decades in this state and this nation. Now, there's going to be lots of distractions, I would predict, Mr. Chairman, and members of the committee today as we present this. But I would submit to you what this bill lasers in on is on the single issue of wrongful abortions in this state and ensuring that doctors operate in good faith and that there's no violation of the rights of protected classes in our state in addressing the procedure. If you look at your packets, the first page in your packet's just a kind of a summary, structural summary of the bill. The second page, its title on the top, it's Coerced Abortions in Georgia. I would ask you to turn to the bottom of the next page, at the bottom of the back end of that page. It's a quote from the United Nations Population Fund. And the UN Population Fund says, quote, coerced abortion is explicitly recognized as a violation of basic rights and principles. I think most in this committee would recognize that an abortion that's forced upon a person against their will is a profound violation of one's rights. And this page, both front and back, cites examples of where violence has been levied against women in either forcing abortions or bring direct violence against them if they refused. Again, the front of this is an example of a young woman who will have testified today, who at age 14 was told by her mother and her grandmother that if you don't have the abortion of this child, and she was, as a 14-year-old ninth grader, as a Caucasian young woman, was told by her grandmother and her mother that we're not going to have a biracial baby in this trailer, that you need to find another place to live or you need to have an abortion. And her mother took her to the clinic, and it was made known to the physicians, the staff at the clinic, and we'll hear that testimony later today. She courageously came today to speak. There's other examples. You can read this. There's examples of where men have murdered their wives and girlfriends over refusing to have an abortion after having made the decision to carry forward a pregnancy that was against the man's will. So you can see, and we can bring example after example if it's important to the committee to do that violence against women takes the form of using the abortion procedure as an extension of the violence of an abuser, and that's one of the things this bill seeks to address under the rubric of criminal abortion. Also in your packet, I have for you here, you see The Economist magazine. I've got the cover piece here, and we've actually photocopied some editions. This is the March 6th through 12th edition of The Economist. The Economist magazine, I think very dramatically, asked the question, what happened to 100 million baby girls? When you look internationally, you can see in the nations of India and China and some other nations in the Pacific Rim that culturally have a bias towards male children, there are literally over 100 million. There's an imbalance of boys to girls in these nations. What strikes you, though, and what I think will strike you all as members of the committee, frankly, it struck me as I started to become informed myself on this issue of the last several months, is we've got a study for you that was put out by Columbia University, peer-reviewed by professors at Berkeley. It addresses the same thing within the continental United States. The study is called Sun-Biased Sex Ratios in the 2000 United States Census. What this Columbia University study outlines, I think, it's a very short, it's just a page and a half, really a one-page presentation. But it shows in the same communities, particularly, and we're not singling out any communities, but culturally it's been seen overseas, and it's played itself out in the United States within certain Asian communities, predominantly, that have the cultural sun-based bias. Then in the 2000 census, for families, first-generation immigrants that had children in the United States, the boy-to-girl ratio for the first child was 1 to 1. There was actually 1.05 to 1. It's right down the line where it would be expected. Surprisingly, though, in the 2000 census, what you saw, if the first child was a girl, the second child ratio was 1.17 to 1. 1.17 to 1. So you can imagine something intervened that for 10,000 years of recorded human history, there's always been a balance of boys to girls 1 to 1. But in these communities, in the 2000 census, what was found in the Columbia University study that for every 6 boys that were born, only 5 girls were born if the first child was a girl. What's more striking, though, Mr. Chairman, I would ask the members of the committee to see just right in the middle of the page, in those same communities, first-generation immigrants, where the first child was a girl and the second child was the girl, the boy-girl ratio for the third child is remarkable. It's 1.51 to 1. 2000 census numbers, a 1.51 to 1 ratio, meaning for every 3 boys that were born, there were only 2 girls that were born. Something happened to that third girl. What really I think is the jaw dropper on this, though, when you see this, is in the study they looked at the 1990 census. First-generation immigrants, the exact same ethnic populations with a propensity towards boys. And what you see in the 1990 census is for first children, second children, and third children, you see absolute parity. It's 1 to 1 no matter what the birth order. What happened between 1990 and 2000? Well, interestingly enough, the ability to profile the sex of the child between 6 to 10 weeks was introduced in the 1990s. Think about that. The only intervening effect from a 1-1-1-1 ratio of boys to girls all the way through birth order from 1990 to 2000 changes to a 1 to 1.51 ratio for the third child if the first 2 children are girls. Again, I would commit to you the Columbia University study, again, peer-reviewed by University of California, Berkeley. Came out in January 24, 2008. Highlights to us that the concerns outlined as an international concern in The Economist magazine, highlighting the practice of gendercide in villages in the remote nations of China and India and some related countries that have led China and India to outlaw the practice of gender selection, much as they have in the United Kingdom and as they have in Korea, makes and brings before this committee a pressing issue. There is a pressing need based on these statistics of California residents from the 2000 census that we have before us today as a General Assembly an issue of direct concern. Mr. Chairman, we've got with us today Randy Beck from the University of Georgia Law School that's going to address these specific issues. And he's specifically going to address the constitutional framework in which these two, the proposition before you rests, and the concept of doctors acting in bad faith, but more specifically the concept of protected classes, of having there being a compelling state interest to intervene on the behalf of protected classes when their well-being is called into question, specifically with regard to the practice of abortion. Before we move on and start walking through the bill, Mr. Chairman, I would also like to highlight to the members of the committee, of course, Dr. Beck has a legal brief he's provided on behalf of, frankly, himself for the committee. But I would also ask if you could dig through your folders here. I've got some letters of support of some leaders from the African American community that have become educated on this. Edward DuBose, the president of the Georgia chapter of the NAACP, submitted a letter on behalf of Senate Bill 529. NAACP Georgia sees this as a direct concern. Have a letter from Dr. Creflo Dollar, World Changers Ministries, in support of 529. The Georgia chapter of the Southern Christian Leadership Conference, Reverend Samuel Mosteller, provided a letter recognizing the support for these issues as being a clear and present need. Dr. Bishop Wellington Boone and Dr. Elvita King from the King for America Foundation all provided letters in support of 529, not from a legal perspective, but from a perspective that there is a clear and present need as a state for us to address this and see this as a relevant concern. Mr. Chairman, as I said, there's an existing law in Georgia addressing criminal abortion. It's within Title 16 of our code. It's been there for years and years. It goes back. It predates, I think, any of us. It's more than 70 years old. And the existing law for criminal abortion makes a criminal abortion that's provided by a doctor outside the legal context of where abortion is legal in the state as a felony with 1 to 10 years. That's the current state of the law. What Senate Bill 529 seeks to do is simply expand the context to address abortions conducted based upon violations of established law. That if abortions are conducted in the context of violations of established law, meaning a violation of the rights of a protected class, or if an abortion is coerced with the compellence being based on a violation of the law, then the physician that would be willingly and knowingly with actual knowledge party to that would be subject to criminal abortion. So again, this bill simply seeks to take abortions that are performed in violation of existing law and ensure that it's applied in a relevant way with respect to our existing criminal abortion statute. Mr. Chairman, I'll walk the members of the committee through the bill. If it pleases the committee, I will simply say there are going to be some distractions today. I anticipate testimony coming up talking about solicitation, people being solicited or targeted. There's nothing in Senate Bill 529 that addresses targeting. There's nothing in Senate Bill 529 that addresses solicitation. There's nothing in Senate Bill 529 that deals with controlling women. There's nothing in what Senate Bill 529 simply seeks to do is it recognizes that it's difficult and frankly, in many cases outside of the scope of the General Assembly, to get in between personal relationships between family members, married people, people having romantic love relationships. But what the General Assembly is in the business of doing is ensuring that the practice of medicine in Georgia is done in a legal way and it's done with integrity. And that those practicing the legal profession aren't party to crimes or other unlawful acts under established law. And this bill simply seeks to close some loopholes and address a context in which licensed physicians in the state of Georgia can today legally perform abortions, but do it in a way that's party to a violation of existing law. That's what this bill seeks to clean up. And I'd like to walk members of the committee through if it pleases the committee.
We're going to go today till 5:30, and it's now 4:25, so
Thank you, Mr. Chairman.
be mindful of our time.
I will be. We'll be respectful of that as best we can. If I could direct members of the committee to lines 14 and 15 of the bill, you see that what this seeks to address is the existing statute of criminal abortion. Code 16-12-140 is criminal abortion. Again, that was first put on the code in the Georgia Code in 1933, and it adds 4 elements to the definition of criminal abortion. 3 of those elements would fall into the same felony framework. One of the elements would only be a misdemeanor, and we'll explain momentarily how that works. The first element, and Mr. Chairman, I'll be assisted here with by Mr. Jonathan Crumley in answering some questions and helping speak to the relevance of this. Mr. Crumley, in addition to representing the Georgia Right to Life Today, is actually litigates cases on this subject matter and has, frankly, a level of expertise well beyond mine.
We got some seats. If y'all can come back away from the door, people try and get in and out and take a seat where one may be available, please. There's some more over here. I believe there's another one back there. We need to try and keep the door clear if possible. Okay. Go ahead.
Mr. Chairman, lines 14 and 15 again, it talks about a commercial who commits the offense of criminal abortion when the person performs an abortion. The scope of this bill deals with doctors licensed in the state to practice medicine who perform abortions. It doesn't seek to address anyone else or any other context. Lines 16 and 17 addresses the issue of unlawful coercion. If the basis of an abortion is that of unlawful coercion, and that's defined down below, and I'll speak to that in great detail here in a moment. But if a doctor has actual knowledge, not imputed knowledge, not the intake technician at the front desk having knowledge, not a nurse having knowledge, but if a licensed physician has actual knowledge that the abortion is being sought as a result of, that the purpose the abortion is being sought is not one's own will, but is based upon unlawful coercion, which, again, we'll see in a moment, is based on a violation of the law, then the doctor, under the premise of 529, would have an obligation to say, I can't perform. This is not a legal abortion for me to perform. You're not doing this of your own will. You're not expressing your own reproductive, your interest in controlling your own reproductive freedom. You're being forced into this by unlawful means. If I could direct members of the committee, I think before there's any real consideration of those lines, I think you've got to jump down to page 2, lines 56 and 57, the definition of unlawful coercion. The term coercion by itself is in the Georgia Code 23 times. It's undefined 22 of those times. And the only time it is defined is in a context of illegal immigration and folks running afoul of immigration law. For this bill, the term unlawful coercion has 3 elements. The first piece is a compellence. Someone's being compelled against their will to do something. Secondly, a commission, an attempt, or a threat. That's the second element. And the third element, which is vital for the members of the committee to understand, is any attempting to commit, is compelling another person by committing, attempting, or threatening to commit any violation of local, state, federal law, or any tort. So the term unlawful coercion has to be based on an unlawful act in its essence. It can't be just a persuasion. It can't just be a boyfriend trying to persuade his girlfriend to have an abortion. It can't be a husband urging his wife to try to persuade her to do something. What this has to be based on to meet the definition of unlawful coercion is a criminal act, a threat, a show of violence, some violation of the law to compel the woman against her will to have the abortion, or any tort. So if there's a tortious activity, there's any number of torts. This committee is well versed in obviously in civil law, but if there's a clear tort committed as a way of bending someone's will against their will, so that they then go forward with the abortion, then the unlawful coercion element is met. Mr. Chairman, that's a vital piece to understand in the coerced abortion element here, because in essence, and this is really the policy essence of lines 16 through 17, element 1, is if a licensed physician has a person come to him seeking an abortion and is not seeking it on their own will, but is seeking it only because they've been compelled against their will by an unlawful act being committed against them, and the doctor has actual knowledge of that, the doctor has actual knowledge that a woman's boyfriend has hit her and threatened to kill her if she doesn't have an abortion, if he has actual knowledge of that and she's communicated that to him, then for him to perform the abortion, knowing that it's not her choice, but someone's broken the law to compel her to do that, that in essence makes the doctor party to a crime. He has actual knowledge that a crime has been committed to force someone to this action. That's the bar we've established for unlawful coercion. Mr. Chairman, again, we'll be subject to questions on that. We can stop there and address that element, or we can move on.
I want to go ahead and present the bill total.
Mr. Chairman, okay.
Because we've got other people who want to be able to speak to it.
Lines 18 through 20 address the circumstance in which if there's a doctor that had actual intent to prevent a child from being born based on race or sex. Don't know how likely that would be. We're not suggesting that it's a common occurrence. But if that were an occurrence, then should it be legal for a doctor licensed by the state of Georgia to seek to perform an abortion to prevent a protected class from having access to life? That's what 18 through 20 does. 21 through 23 we think is certainly, by virtue of the statistics we provided in the Columbia University study, is much more likely. That doctors could have actual knowledge that the purpose the abortion is being sought is to prevent an unborn child from being born based on the race or color, or the race or sex of the child. In this context, if a physician has actual knowledge that the mother seeking the abortion to prevent a child from being born because it's a girl, or because it's a boy, or because it's a biracial child, or any other racial basis, if the doctor has actual knowledge of that, then the doctor going through and performing the abortion, in essence, is party to an act of eliminating a protected class from being born because of an inherently discriminatory act. For more than 5 decades in this country, we've had established protected classes. You know, it's interesting in the state of Georgia, you can hire and fire in a right-to-work state for just about any purpose. I can, if I work for Representative McKillop, he could fire me because he doesn't like orange. And this is Auburn colors, and he's a UGA guy. He could hire or fire me for almost any reason, but one reason he couldn't. He couldn't fire me because of my color or because of my sex. You know, he couldn't say, you know what, I really want to have a girl for your job, so Ed, you're fired. Because sex is a protected class, and it has been for more than 5 decades. What this simply seeks to address is the proposition that you can't hire and fire people based on race or sex. The Civil Rights Act of 1964, 65, reaffirmed in 91. You can't prevent people from buying or renting a house because of race or sex, the U.S. Fair Housing Act of 1968. These protected classes have been established for more than 5 decades in this country. And the notion that one could prevent someone from being born because of race or sex, but couldn't prevent someone from getting a job because of race or sex, that's an inconsistency that this bill is simply seeking to clean up as part of SB 529. Lines 24 and 25, the code sections referenced are existing law. Those are laws. First section is the parental consent law. Second section, 1612-141, is the trimester restrictions, first trimester, third trimester abortions. The existing provisions, it simply brings them into one place and allows them to be enforced here. And 31.9a, 3 and 5 deal with the Women's Right to Know and the Ultrasound Act, existing law, and makes it simply a misdemeanor, not a felony, but a misdemeanor treatment for violations of those existing provisions. Second page, you can see again current code with respect to criminal provisions. You see the misdemeanor treatment on lines 28 through 29 for the enforcement of the existing provisions. Again, existing law with respect to the legal context for parental consent, 24-hour notice in which abortions can be legally performed. Violation of those would only be misdemeanors, as presented here. And then lines 30 through 57 really address some legal provisions that I'd love to walk through, but I'd prefer if Mr. Crumley could walk through as a practitioner in this area. I think it explained lines 30 through 57 in a more compelling way. Mr. Crumley.
You want to speak briefly to that, Mr. Crumley?
Thank you, Mr. Chairman, and members of the committee. For lines 30 to 36 are essentially a safe harbor for physicians. A question's been asked, how do we tell doctors what to do to make sure they're doing it right? This provision provides physicians with a clear roadmap for making sure they're staying on the right side of the law and they're complying with this statute, and it gives them a safe harbor and absolves them from any criminal prosecution if they follow these clear procedures. Requires they take the initiative to personally confirm by direct inquiry these issues that are addressed, and then they obtain certification to that fact. That then bars any criminal prosecution, gives them a safe harbor.
Do I understand it bars criminal but not civil?
Yes, that is correct. The civil provision is a little bit further down. That, in tandem with the modification of the peril evidence rule, is an attempt to try to balance the equities between a civil case and a criminal case, given the context where, particularly in dealing with coerced abortions, those are very complicated and difficult sets of circumstances. The next section, E and F, lines 37 to 42, those deal with explicitly providing the private right of action, the civil cause of action to women who are forced into these situations or undergo these circumstances, and modifies the wrongful death code here in Georgia to provide for a civil right of action for the full value of the life of the child. Section G, lines 43 to 45, provide immunity to women so that they cannot be either criminally or civilly held responsible. That is a clear acknowledgement of the existing constitutional right to an abortion, and it's a clear attempt to make sure that there is no impermissible hurdle placed by operation of this statute. The balance, Section H, lines 46 to 48, deal with, again, the peril evidence rule, given particularly the coercion context where a woman's will has frankly been overcome by an illegal act, by unlawful coercion. As everybody on the committee knows, you're practicing attorneys. You go to any medical procedure, you sign a stack of documents. There will be waivers that will be drafted. There will be documents that will be drafted. This is a provision that simply doesn't take away the effect of those waivers in the sense that they will still be able to be used against women that change their mind or come forward afterwards and say, hey, this was due to coercion. I did not get asked these questions. It did not happen this way in the examination room. It did not happen this way at the abortion clinic. They will be allowed to testify unencumbered. The defense counsel will be able to use those waivers against them. It will frankly become a jury question at that point as to who is the more believable person in this scenario. The Section I, 4950, that simply provides for mechanisms to report any criminal investigation being conducted by either a solicitor or a DA in a county to involve the Georgia Composite Medical Board, because again, this is directed to the regulation of the medical industry. Then Section J, lines 51 and 52, preserve patient confidentiality and in compliance with various regulations relating to that. And then the final section of Section 1 are the definitional sections. Representative Setzler's gone over Part 2, the unlawful coercion definition. Then unborn child is defined. It is consistent in exactly the same language that's in the existing infanticide statute here in Georgia.
In fact, Mr. Chairman, and members of the committee, this definition is the same definition throughout Title 16 for unborn child. So there's no change here. We've just restated it for purposes of clarification in the code section. The rest of Section 2 is in essence, if you look, the way the abortion statute's crafted in Georgia is a little confusing. What Section 2 simply does, it adds in the existing exception under the current code with respect to abortion, provides for an exception to the categorical ability to perform an abortion under any context. It's provided in 1612-144, which is the partial birth abortion statute passed back in 1997. What this simply adds is the provisions of subsection B would be exemptions from that. It would provide the context in which a physician couldn't perform an abortion, i.e. being based on unlawful coercion or being based on an intent to prevent those protected classes from being born. 68 through 72, again, provides an exception for the life of the mother. If the life of the mother's been endangered, this allows it allows under all those contexts for the abortion to be performed. The language added in lines 68 through 72 has made it all the way through the United States Supreme Court. That's the exact language lifted out of the Gonzales v. Carhart case that provided the life of the mother exception. So this language was lifted without any changes precisely because it's withstood constitutional muster. Section 3, Mr. Chairman, wraps up. It simply would allow criminal abortion to be pursued under a RICO framework if such conditions existed and were found relevant by the prosecution.
All right, we have some questions, I believe. Mr. Bruce.
That was a lot that you just went through. And, let me state, for the record that I personally don't approve of abortion. But I do believe that a woman has a right to choose whatever it is that she needs to do for her own medical health and the medical health of her child, unborn child. But I find it coincidental that you are saying that coercion is the basis for this bill, that the doctor should not, or the people should not be coerced. But what you're doing with this bill, at least I'm asking the question, what it appears that you're doing is you are coercing the doctor into not performing a service of counseling and helping a woman with the medical thought process. All that stuff that you just said, the average doctor is not going to understand all of that. And they are going to probably err to saying, I'm not going to perform this abortion. I'm not going to do this because of fear of being arrested or a fear of being prosecuted or even just brought to trial. So it is coercion that you are saying that you're against, but it is coercion that you are using to force the doctor. And again, I want to be clear. It appears that this is just another attempt to stop abortion. And if that's the goal, then just say that. And again, I just think that this is a test of people's intelligence. That you are trying to make this appear that this is a good thing for women to tell them that their doctor could be arrested, and it's coercion. I know it wasn't a question, but I needed to get that out.
I want to respond to that, one of you.
Sure. Good. Mr. Crumley is going to share something from an existing operating procedure of a clinic here in the state. I will say, I think you would agree, or would possibly agree, that if a doctor has actual knowledge that a woman doesn't want an abortion, but she's there because she's afraid she's going to be killed or someone's going to beat her face in if she doesn't, and the doctor has knowledge of that a professional would exercise judgment and not go through with that. And to that point, we've got...
Be better if a person felt the coercion that you just talked about, that they should go to get some to basically get that person arrested for making that kind of threat. Not to take it out on the doctor, but why would you not go to the police and tell the police officer that I've been threatened with my life if I do what I think I need to do? That seems to me to be something that you go to the police and not to the doctor.
Well, thankfully, those remedies exist. That if someone went to the police against their boyfriend or their spouse or otherwise, those remedies exist. The problem is, what happens today is people are using the otherwise legal procedure of abortion as an extension of the terror. They use the fact that physicians can perform an abortion for any or for no reason to their advantage to keep from having to pay child support and to force their girlfriend or the person they have a relationship with to do something they don't want to do. And if all this says is, doesn't change the ability to pursue action against the abuser. It simply says if a doctor has actual knowledge that the abortion procedure is being used as a tool of that abuse, he can't perform it. And I think the current procedure, that's we've got. Mr. Crumley would just add something briefly.
Very briefly, the existing lawsuit. It's in DeKalb County, Renee Weimer versus Northside Women's Clinic, an affidavit signed by Grady Strickland, who was the medical director for that abortion clinic, which conducted the third highest number of abortions in 2008, according to state health statistics, signed an affidavit in support of summary judgment, clearly testifying that and this is a quote from his affidavit, as a surgeon who has performed numerous pregnancy termination procedures at Northside Women's Clinic, from the time a patient checks in at the clinic until the procedure is performed, if there is any question or indication whatsoever that a patient is not freely and voluntarily consenting to the procedure, that she is being coerced or threatened by others to undergo the procedure, that the decision is not her own voluntary decision, that she is not sure whether she wants to the procedure, etc., that the appointment is canceled, the procedure is immediately halted by the clinic staff or me, the doctor, or another physician, and the patient is sent home. Also, this statute provides a clear safe harbor for all physicians in the state to directly inquire as to whether or not any of this is going on if they get confirmation.
That's a medical standard.
Correct. This is the standard of care that this doctor, the medical director of that clinic, again, that provided the third largest number of abortions in the state of Georgia in 2008, has already been trained to recognize these scenarios at a much lower standard than what's in this bill. And again, the bill gives them a safe harbor.
Was yours pushed, Mr. Lindsay?
Yeah. Well, two points. Well, let me start with what is actually a pure question. Y'all may not be able to answer this. Perhaps, though, if we have a doctor coming in to testify that they can. We were requiring this over here a moment ago.
We've got several, I think, we'll call.
What are the medical reasons for asking for determining the sex of a child in the first trimester? Are there any medical reasons in this pure question here?
Can you determine that early?
Yeah, Mr. Chairman, that was one of the things we laid out.
One of the points he was raising.
It's 6 to 10 weeks that can be determined.
Okay.
Yeah, I was just sort of curious about that.
Mr. Chairman,
the doctor.
Let
me get some questions to you. Ms. Stevenson.
Thank you, Mr. Chair. I have a couple of questions. Thank you for presenting the bill. You started off several threshold issues. What is the protected class that you used to make it akin to the Title VII Act of the Civil Rights? What's the protected, because I think it's a protected activity. What is the protected class you were describing?
Okay.
If I may, just in the employment context, if the decision to follow through with the abortion is motivated and purely by terminating the pregnancy because it is the wrong gender, because it is the wrong color, because it is the wrong race, that is where we get into the compelling state interest in regulating the medical profession to stay away from those kinds of procedures. From a legal point of view, how can prohibiting racism and sexism and the opportunity to be born be less worthy state interest than banning racism and sexism in employment or where you can eat? I mean, this is a decision, and this law is specifically crafted to address only those scenarios outside of the coercion, but in the race and gender, where the sole motivation for the procedure is because of an immutable characteristic of the child.
Okay. Well, I don't think that's an analogy, because in the Title VII, it has to be a legitimate business interest. It shifts under the McDonnell-Douglas, and it's a prima facie case, so I don't see those as being anywhere near similar. But in this case, when you talk about the physicians operating in bad faith, I believe you started on that. Is the bad faith that you're addressing that you're saying under the current voluntary consent that women have to sign, there is bad faith that physicians are not, or the clinics are not inquiring? Because you just read an affidavit that supported what appeared to be a very lengthy inquiry.
Right.
I can direct the affidavit. The testimony of my client is exactly the opposite. She was never asked any of those questions. She, in fact, was never even spoken to by anybody at the clinic. That's clearly a conflicting issue of fact between my client and the clinic staff. But the position is, and the testimony via verified affidavit in explicit factual detail is that my 16-year-old client was never spoken to by anybody at the clinic before performing the abortion.
Mr. Chair, I have just three more
Okay,
questions
go ahead.
related. Paragraph 3, lines 21 through 23. That is not based on coercion. Is that right?
That's correct. 21 through 23, the way this is constructed is the physician has actual knowledge the abortion is being sought based upon. That's language that's lifted out of other related civil rights law, based upon race, color, or gender of the unborn child or the parent, race or color of the parent. That deals with actual knowledge that it's in essence a gender-based or a race-based abortion.
Okay.
And again, the thinking is that if the doctor has actual knowledge of that, should it be a legitimate act to follow through with the abortion?
Okay. I understand actual knowledge and constructive knowledge under premises liability, but when you include those words that describe discrimination, it becomes a little bit vague. The idea that you're trying to address in I think it's 162140, is to, you said unlawful coercion, that's not defined. Well, the physician is the only person or agent that could be charged with the crime. Is that correct in this bill?
Correct.
Okay.
And again, I would refer you to lines 56 and 57 for the definition of unlawful coercion.
I understood that, but the person who's actually perpetrating the crime, the alleged crime, would never be charged.
They can be charged under existing law, and our hopes would they certainly would be.
So they would be parties to a crime.
In essence, the doctor would be party to the crime of the abuser. That if the abuser has communicated a threat or hit someone, bludgeon someone, threaten to kill someone, that underlying crime is prosecutable today under existing law.
Okay.
And what this simply says is if the doctor has actual knowledge of that and he carries through with the abortion, then he's in essence taking an otherwise legal procedure, abortion, and using as a tool to be party to the crime. And should the physician have actual knowledge of that?
Okay, let's get this.
Sure.
Mr. Bruce, did you have another question you wanted to ask?
They addressed it, I'm sorry.
All right. And I believe Mr. Lindsay.
Yeah, given the affidavit that you read, I am curious in regards to the drafting of the bill, why you didn't focus on making sure that this is an informed consent in terms of counseling to the patient. In other words, why you didn't focus on ensuring that the doctor has properly counseled with the patient to ensure that the patient is not there as a result of unlawful coercion. Why isn't that the primary focus of the bill? Or should we try to make sure that that is the primary focus of the bill? In terms of the coercion aspect.
Mr. Whip, if you could look on lines 30 through...
I realize the safe harbor aspect, but that's sort of almost the after the fact. But in terms of simply just requiring that the doctor make a inquiry and counsel with the patient to ensure that coercion has not taken place.
I will tell you, in drafting the bill, we believed it, rather than getting into directing the medical practice, thou shalt do this, there's a lot of provisions that talk about, I mean, our existing law says...
Well, we do that in several other, I don't mean to cut you off, but unfortunately, and I do apologize, Mr. Chairman, A, time-wise, and B, I hope the audience understands that unfortunately a lot of us have to go to other places, and Senate Rules is about to meet, and I'm going to have to go out, and I apologize to the crowd for leaving, but I do want to get my point across, is that we do direct doctors to do things in other areas when it comes to counseling with patients to ensure that they follow the standard of care in other areas, and I'm just wondering why we don't sort of focus on that in this bill.
Those provisions are already there.
Yeah.
If you look in 31.9A3, it talks about the 24-hour waiting period, the counseling that has to happen. That counseling already exists as a requirement under existing law. What we're doing here is saying if the doctor actually talks to the person and gets the consent, then that's where the safe harbor kicks in. So in essence, through the liability provisions, we do that because the existing law is already exhaustive in directing that counseling.
Okay. And Chairman, I want to make sure just to apologize to the audience that unfortunately Rules is meeting.
Yes, several has got bills up there. I'm going to ask at this point in time, go through the other persons who have signed up, want to present. That's Professor Lynn Hogue. There you are. She did? Okay. Okay. You have some written testimony. Fine. If you will let that, give that to Mr. Chester, he'll get it copied and distributed. Dr. Andy Toledo, please come around, and I'll let you all excuse yourselves from the seats, and we'll have others present at this point in time. Dr. Toledo.
Thank you, Mr. Chairman, and I want to thank the committee for allowing me to testify, and I am testifying against this bill. I want to make that clear. I am a licensed physician practicing OBGYN and reproductive medicine here in Georgia. My practice is at Northside Hospital. I'm also legislative chair of the Georgia OBGYN Society, and I come with distinct worries because my members are concerned, and that's a massive understatement, about the potential backlash of this bill. I want to start off by asking the question. I'm a little intrigued as to how you can determine sex at 6 to 10 weeks gestation. I have some perinatology colleagues with me, and to my knowledge, I don't know of a test that allows to determine sex at 6 to 10 weeks gestation. I mean, you can certainly start to see parts develop, in answer to Representative Lindsay, further on in the pregnancy, but not at 6 to 10 weeks. So I'm puzzled as to how we can determine sex at that stage of gestation. My concern is just this. I don't think any physician that I represent has a moral, ethical problem with the intent of this bill. And I would find it very reprehensible if any of my members would knowingly commit this kind of act. What I have real concerns with is this. As Representative Barnes stated, I have real concerns about what could happen with this bill and what my members are going to worry about when they talk to our patients. They are going to go in now with much more of a defensive mode of concern that their words are going to be misconstrued. The doctor-patient relationship is going to be violated because what goes on between doctor and patient now has to be processed in many different ways. And quite frankly, my members and people that do what I do are going to think very, very seriously about not providing a service that may be an appropriate service to do because they have been pressured that they're going to go to jail. And that could only lead to a lack of good care for our patients, and certainly a lack of physicians practicing, some kind of decent medicine here in Georgia. So I want to state that for the record. We have other physicians who will testify to specific things here, but I want to thank this committee for allowing me to think about that and just understand we are worried about how this bill will affect our ability to take care of our patients, and we think that it's going to have a negative impact on our ability to do that. Thank you, Chairman, and thank you, Committee, and I'll be happy to answer any questions.
Do we have questions of Dr. Toledo? Yes, sir. You have questions.
Thank you, Mr. Chairman. I just have a quick question. You used a term a minute ago that said that this bill, you had concerns that it would prevent you from providing what you termed as good care.
Sure.
What did you mean by that?
I would say this, that if, and all of the physicians that are here have been through this process before, sometimes what we tell a patient, what we think she is hearing, and what she may hear because of the emotional stress of a process, because of where she is in her own situation right now, may be misconstrued and may not be what she heard. Now, I, in good faith, have given her the best knowledge, the best information I can. If she states that she understands that, and yet somewhere down the road she says that's not what I heard, we have a problem.
Are you talking about some type of communication gap or a misunderstanding between
Correct.
What coercion might be?
Correct, exactly that. And that is my concern with this whole bill, is that it's easy to look at the hard parts of this, the parts that say yes. If someone comes in and somebody has a gun to that person's head and says, yes, you're going to have this procedure, I mean, really and truthfully, what physician is truly going to do that? I mean, if they are, then I don't have a problem with the intent of this bill. I don't think any member of my society would. But it's the devil in the details here that says, that's not what I heard. I heard this, for instance, if truly this young lady that's going to testify did not get talked to about, what she was doing, then shame on us because we did a bad job of talking to her about that. But I am worried about how this bill can be represented and can be misconstrued, and someone who's saying something now and agreeing to it now coming back later and saying, that's not what I really meant. That's not what I really felt. How do you prove that? That's my problem.
Other questions of Dr. Toledo? Well, thank you for being here, Doctor.
Thank you.
You have one? I'm sorry, a little late there, Mrs. Oliver. Go ahead.
I'm trying to put together the safe harbor language which requires, in order to have a, quote, safe harbor, that you have a patient sign a written statement that says, I'm not being coerced. I'm trying to put that language together with criminalizing any abortion that is based on gender or race. I'm confused here about what kind of statement you're going to ask a patient to sign.
It's your guess is as good as mine.
It seems to me like it's a multiple choice.
Yeah. It's my problem with the bill. I mean, and that is that, I also have a problem with the bill that somehow you could have someone sign something and somehow later they could come up with a witness that said that you didn't sign that. I don't know how that's done. I mean.
Thank you. All right, Doctor, appreciate you being with us. And next we have is Dr. James Smeltzer, I believe. Is that correct?
That's correct.
Yes, sir, Doctor. Thank you. Have a seat with us.
Hi, thank you for this opportunity. I'm Dr. James Smeltzer. I've practiced over half my career in Georgia. I'm a pro-life OBGYN. I'm medical director. I have been a medical director for a couple of years of a very pro-life pregnancy counseling service. Personally, in that capacity, with my own hands and my own mouth, I've saved enough babies to pack this room at least 3 times in the last couple of years. I am, just so you know where I stand, my license plate says it for me. It says choose life. And thanks to the state of Georgia for the opportunity to say so. My specialty is prenatal diagnosis and high-risk pregnancy management. My business is saving babies. I can say as an absolute fact that I am against this act because, first of all, it contemplates a problem that doesn't exist. Physicians are not willingly committing battery on our patients. And that's essentially what you're saying. If somebody's got a compelled consent, it's worthless. And if there's a witness to the fact that the consent was compelled, it's worthless. And if we know about it and act on it, there are already remedies for that under existing law. Battery and sexual assault are both applicable if you enter a woman's body with knowledge that she has no effective consent. This is something you've already taken care of. I've never seen a woman who was actually coerced to have an abortion. And the thing about sex, we understand that women of certain cultures feel a need to have male children. But there's really not anything we can do about that. And for us to intervene in that is social engineering. That's the antithesis of the Constitution and Bill of Rights in this country. And keep us out of that. So it's a remedy for a problem that doesn't exist. And the remedies are already in place. And we don't want to be instruments of social engineering under any circumstances. This bill presumes that a woman's free consent and presence for a procedure isn't good enough. What does that say about that woman? That's fundamentally disrespectful of women and their ability to speak for themselves. And I'm really against it. Some of the toughest things I do are counsel women who have babies with known problems. And yes, there are genetic problems that are based on sex, such as Duchenne's dystrophy and X-linked hydrocephalus, where a boy can have it and a girl that carries the gene doesn't have a problem. This counseling is extremely difficult. I don't ever tell a woman she should have an abortion, ever. But I have to tell them that the baby is going to have certain problems. I have to tell her that this is an option for her. But this is an extremely stressful and difficult time for me personally. I don't need Darth Vader in the room threatening RICO statutes and my medical license and hard jail time if she construes that later as it being a compelling event. Because I've personally got it in my experience in very recent memory that women and their significant others can have very distorted experiences under this degree of stress. That's to be expected. And to give them some way to come back later and say, well, you didn't do this or you did that is wrong. I'm doing my best. And I'm definitely pro-life.
Thank you, Doctor. Any questions of Dr. Smeltzer, please? Looks like not. Thank you for coming. Next we have is Kathleen, is it Birch? Excuse me. Sorry. Come on, Ms. Birch.
Good evening, and thank you for allowing me to come to testify today.
Glad to have you.
I'm on the faculty of John Marshall Law School and teach constitutional law. SB 529 purports to protect women from coerced abortions, but in fact creates an invasion by the state into the intimate relationships of the family. In order to comply with Senate Bill 529, the doctor must ask the pregnant woman with whom she has engaged in sexual relations, and more precisely, the doctor must ask the race and color of the patient's male partner. It is this precise type of invasion into the bedroom that the United States Supreme Court held unconstitutional in Griswold v. Connecticut and Eisenstadt v. Bard. When the woman enters the doctor's office, the doctor will know, either visually or by answers to the common health history completed by the patient, the race and color of the woman. Unless SB 529 is premised on the idea that a woman does not want to bear a child of her own race, which, if true, one would suppose that the woman would take precautions not to conceive, then the focus of SB 529 must be on the race and color of the male partner and assume that the male partner is of a different race than the woman. Thus, SB 529 places a disproportionate burden on interracial couples. Given Georgia's history of race relations, it is difficult to disentangle SB 529, particularly its impact on interracial couples, from Georgia's history of Jim Crow laws, including its miscegenation statutes. When interracial couples seek to terminate a pregnancy, SB 529 requires that the doctor inquire whether the reason for the abortion is due to the race of the fetus, a mix of both parents. In order to avoid the inquiry into their personal relationship, the interracial couple must either not terminate the pregnancy or must not enter into the relationship. The interracial couple is thus placed in the position to choose between two constitutional rights, and likely will lean towards choosing the least intrusive right, which would mean the right to choose to avoid to enter into the relationship, thus not creating the interracial child. In Loving v. Virginia, the U.S. Supreme Court held that an individual has a right to choose with whom they wish to enter into the intimate relationships. Because SB 529 places an undue burden on the rights of interracial couples to choose how they wish to develop their families, it acts as a disincentive for individuals to exercise the rights recognized in Loving v. Virginia. Some additional problems, in addition to what you've heard from the doctor, is that SB 529 includes no exemption for women or girls who are victims of rape or incest. These victims of crime will be subject to questions regarding the reasons for an abortion at a time when they are already vulnerable and perhaps at a time when they do not know the race of the fetus. The state has no legitimate interest in requiring that a woman explain why she has chosen to exercise her constitutional right to choose to terminate a pregnancy. Okay. Motive is irrelevant to the constitutional analysis, and by requiring a doctor to determine the woman's motive for seeking an abortion, SB 529 places an undue burden on the woman's right to choose. That burden is undue for two reasons. First, the requirements which the Supreme Court has upheld in the past, requirements which Georgia now has on its books, limiting abortions, have been ones in which the information provided or information provided to the woman is informative, and it is required that the woman receive that kind of information for other medical procedures, regardless of it, whether it's abortion or removing an appendix. The requirements of SB 529 is a requirement for the woman to divulge information, not for information to be given to the woman to inform her decision. And SB 529 requires a woman to provide this information when that information is not required to be provided for any other medical procedure, either to be performed on a woman or be performed on a man. The second reason that this burden is undue is, although we have heard today calls of a safe harbor provision, I would actually say, after having read the statute, that there is no safe harbor provision. Perhaps if the doctor asks the correct questions, and we can't be sure exactly what the correct questions are that are required under lines 30 through 36 of the statute, that only pertains to the criminal liability. Okay? This bill leaves open substantial civil liabilities to the doctor. So there is no safe harbor provision. Perhaps the doctor might not go to jail because there'll be no prosecution, but the doctor will be sued. Okay? And if we have this amount of liability open to doctors, where women or their partners can come back and sue for a wrongful termination of pregnancy, then we know that there are going to be cases filed in court. We know that the insurance companies are going to increase malpractice insurance, and what we'll have in the end is that doctors will not perform abortion services. And so there is no safe harbor provision, because the doctors will end up in civil court being sued, will not be able to afford their malpractice insurance, and what that will end up doing is doctors will not provide abortions, and they will leave women with a right to a medical procedure, which in reality is a right that they cannot exercise, because they will not be able to find a doctor in Georgia that is willing to perform the procedure. Thank you for your time, and I'm willing to take questions.
Thank you, Ms. Birch. Any question, Ms. Birch? I think we have one question over here. Ms. Oliver.
Thank you, Mr. Chairman. If you're correct that a woman has a constitutional right to choose to have an abortion, regardless of motive, how can you criminalize the doctor for performing a service that she has a constitutional right to have?
I don't think you can criminalize the doctor for performing a service that the woman has a constitutional right to seek, if I understood your question correctly. And if I might add, the Supreme Court has not recognized an unborn child as a protected class. The protected classes are the people who are in being, and that is the parents. And in particular, in this kind of a situation, I would say the men and women who are entering into these relationships, particularly creating the interracial child.
Thank you, ma'am. Anything further, Ms. Oliver?
No, sir.
All right. Well,
thank you very much for
your
time.
Be with us today. I'm going to Dr. Randy Beck, Professor Beck.
Mr. Chairman, members
Yes,
of the
sir.
committee, thank you.
And we've got your, I think, comments, don't we?
You do. You have a letter
Yes,
that
sir.
I sent in late March.
Right.
And by the way, no need to promote me. I'm not a doctor. I'm
All right.
no PhD. So, I teach at the University of Georgia School of Law, and I cover the Supreme Court substantive due process cases in my constitutional law course there. I've written 2 articles on abortion rights, particularly in the context of late-term abortions. I sent the letter that you have in front of you, and I just wanted to be here to expand a little bit on what I wrote there and to answer any questions you might have. Let me make clear that I am not here to speak to the merits of the legislation or whether you should or should not adopt it. I'm here speaking only to the constitutional issues. One provision of Senate Bill 529 would make it illegal to perform abortions knowing that the woman is seeking to terminate the pregnancy as a result of unlawful coercion. That measure seems calculated to protect a woman's autonomy in deciding whether or not to have an abortion. I to date have not seen any argument made that that provision would violate the substantive due process rights of the woman who is seeking medical care. The more difficult issue, I think, under the Supreme Court's case law has to do with the provisions forbidding sex-selective or race-selective abortions. As an initial matter, I think there's some question whether those provisions are likely to be challenged prior to enforcement. I'm aware of 3 states that have statutes prohibiting sex-selective abortions: Pennsylvania, Illinois, and Oklahoma. With respect to the Pennsylvania legislation, I saw an article indicating that Planned Parenthood had passed up an opportunity to challenge that statute because of standing issues. And it's not difficult to imagine that it would be hard to establish standing for a pre-enforcement challenge to legislation like that. On the merits of the substantive due process issues, some of you may have already seen the testimony that Professor Lynn Hogue of Georgia State offered over in the Senate. I know he's offered some written testimony as well. I haven't seen his latest testimony, but the position he took in the Senate was that the courts would view these provisions of the legislation as a violation of Planned Parenthood versus Casey because they would place an undue burden on the right to an abortion prior to viability. I think that's a plausible analysis under the existing case law. It may be the way the courts would in fact analyze a challenge to these regulations. At the same time, as I mentioned in my letter, I think there are counter-arguments that can be made, and that those counter-arguments potentially could persuade a majority of the Supreme Court to uphold restrictions like the ones that are being considered here. If you look at the Supreme Court's jurisprudence over the last 2 decades, I think what you see is a distinct, significant movement in the direction of permitting greater state regulation in the area of abortion. That movement is epitomized perhaps by the most recent decision, Gonzalez versus Carhart, which upheld the Federal Partial Birth Abortion Ban Act of 2003, even though the statute applied to some pre-viability abortions. I can envision at least a couple of routes by which the Supreme Court could reach the conclusion that a provision regulating race-selective or sex-selective abortions is constitutional. First of all, Justice Kennedy has argued in his dissent in the Stenberg case that it is inappropriate for the judicial branch to provide an exhaustive list of state interests implicated by abortion. I think we see a majority of the court embracing that proposition in Gonzalez. Justice Kennedy's opinion mentions a number of different governmental interests that were furthered by the federal statute, distinct from the interest in preserving fetal life. It's true that the majority in Gonzalez assumed that the government could not place an undue burden on obtaining an abortion prior to fetal viability, but it's also clear that they were stating that as an assumption. And the dissenting justices thought that the majority was not faithfully applying the viability rule from the prior case law. In my academic writing, I have argued that the court has never given an adequate constitutional justification for the viability rule, for treating that as the controlling line. And so that I think the court should reconsider that aspect of their jurisprudence. But even if the court continues to apply the viability rule when the state advances an interest in protecting fetal life, it's not clear why that line would control if the state was pursuing some other interest, such as an interest in preventing discrimination based upon the race or gender of the fetus. It's just not clear what viability would have to do with those state interests. Alternatively, I think a majority of the Supreme Court could conclude that a law preventing abortions motivated by the race or gender of the fetus is a relatively minor restriction, and that therefore it shouldn't be deemed to create an undue burden on abortion rights. I don't mean to suggest that either of those arguments will necessarily prevail. It may be that the courts would find the provisions of Senate Bill 529 regarding race-selective and sex-selective abortions invalid, at least insofar as they apply prior to fetal viability. But I also think it's possible that a majority of the current Supreme Court could be persuaded to uphold those provisions. So I don't think the outcome of a constitutional challenge is a foregone conclusion. I'd be happy to try and answer any questions about those issues or anything else in my area of research.
Thank you, sir. We have a question. Ms. Oliver.
Thank you. Do you agree or disagree that the Supreme Court would have to overrule Roe v. Wade in relation to the right to have an abortion in the first trimester and determine that motive is a barrier to the woman's right to choose in order for this bill to be upheld?
I don't think they would have to overrule Roe versus Wade. I think they would have to conclude that this is a compelling state interest that would permit state regulation, and that would be permitted even in the first trimester.
I think that's where you and I disagree on the constitutional issue.
Okay.
Further questions of Mr. Beck? And you've read the bill. Do you find what is being done as far as the issues of the coercion question as being a constitutional ability that the state would have with enactment of this law?
I focused on the substantive due process issue. I have not looked at other possible constitutional issues.
Okay, under the due process provision.
I did not see that provision as problematic as a substantive due process issue.
Thank you. Next we have, I'm getting doctors and the professors out because I know they are here, have been waiting a good while. We're going to go next to Dr. Kevin Gandy. Is that? I'm sorry, sir. I messed your name up. Gomez. Excuse me. Dr. Gomez.
Yes, hi. I work as a perinatologist in here in Atlanta, and I want to thank Chairman and the other committee members for allowing me to speak today. As a perinatologist, I am trained as an OBGYN, but have gone on and done more specialized training dealing with complications of pregnancy, women that may have problems with things like diabetes, high blood pressure, specifically with problems related to unborn babies that may have birth defects or things that may need to be treated in utero. And we see many patients. I come from a group of 10 perinatologists here in Atlanta, and we see individually anywhere from 26 to 30 patients a day. And the vast majority of what we do, besides ultrasound and prenatal diagnosis, looking at gender, looking for birth defects and things of that nature, is counseling women related to problems that they have during the pregnancy. So we don't see patients that have quote-unquote normal pregnancies. If they see us, it's because there's some kind of problem with the pregnancy. So one of the problems that we have with the bill is really, you've kind of addressed it many times with the whole issue of coercion. And we counsel patients in depth, and most of these patients are in a very emotionally unstable setting because they come in, they may not know there's a problem to begin with, or they do, and here we are trying to counsel them about this problem. And with informed consent, our responsibility to the patient is to really give them as much information as we can related to what's going on with the pregnancy and the problems that are there. And we give them information related to gender. We give them information related to a birth defect. We tell them what the risk and complications are with that particular pregnancy, regardless of what they plan on doing with that information. So one of the problems that we see is that this kind of information that we're giving and doing an informed consent, because it's an open dialogue, is that this could be something that could come back and haunt us, where this could be construed as some kind of a problem that's being given to the patient, and we're responsible for what they do with those actions.
You're talking about giving them the information itself that may be a problem of birth because of a defect.
Exactly.
And now, by giving that information, they may feel, well, I need to do something to abort the birth of this child.
Well, we do non-directive counseling, so we're not telling them they should or shouldn't have an abortion.
Construing.
Right, but that can be an issue where patients that have problems that we're addressing when we do this counseling don't always remember everything that we're talking about, because it's usually a very intense counseling session with as many issues and problems that we're talking to them about. So yes, this could be something that they could misconstrue or come back to say that we didn't give them information, or maybe that they thought we were directing them. But as physicians, we do non-directive counseling. We do not start out with thinking that we're trying to get a patient to do something. We're there for them to have the best possible outcome that we can.
Great. Thank you, Dr. Gomez. Any questions of Dr. Gomez? We appreciate your being with us today. Where am I on the doctor list? Dr. Jacqueline Fincher, is it? Do I have that right?
Yes.
Thank you, Doctor.
Thank you. Appreciate the opportunity to be before this committee. Dr. Fincher from
Thompson, Georgia. I'm actually grew up here in Atlanta, and I practice in rural Georgia as a general internist. I am a second-generation physician, as is my husband, and we're hoping we got a third generation on the way. I am also here to represent the American College of Physicians, which is the 2,300-member organization that represents all the general internists and the internal medicine subspecialists here in the state of Georgia. We are here in opposition to Senate Bill 529 because we are very concerned that it puts at risk the very sacred physician-patient relationship. We're concerned that it puts it in great jeopardy. This relationship is based on truth and trust between both the physician and the patient. Every patient must be able to come into the exam room knowing that they can be totally honest and vulnerable with their physician, that they can share anything, truly anything, knowing that that physician will treat them with respect, honesty, and compassion. Training of physicians is different than training of lawyers and training of business people. As I understand it, business people are trained in negotiation, representing their company, having the knowledge that they have, and using all the resources that they have to get the best deal that they can make on behalf of the company that they work for. As I understand the legal profession, that lawyers are trained to defend a position. A client, whatever that client position is, they are there to look at the case law, the precedents there to defend that position, whether that is seen by the jury or a judge and rules in that way or not. Physicians are trained differently. We're trained in informed consent. We are trained to fully give patients in any type of procedure a written document that says what the procedure is, explained in layman detail, given the risk and benefits of such a procedure, the potential complications, including death, dismemberment, and any other complications that may occur from that. That document is not only signed by the patient and the physician, but is also witnessed. So it is a very rigorous procedure that we are trained in doing, and we do every day. Now, this bill jeopardizes the ability of physicians to give that fully informed and full disclosure of any procedure with its risk and benefits and potential complications. Physicians and patients must be honest brokers with one another for that relationship to work at all. Physicians and patients must speak with all candor, and that information must remain inviolate of that doctor-patient relationship. We must meet patients where they are, not where we wish they would be, just as God meets us. Physician counseling of patients should not be subject to tort and civil liability, particularly in retrospect. It would be totally crippling to physicians to do what we are bound by oath to provide, which is the truth. I'll be happy to take any questions that you may have.
Thank you. I believe we have Mr. Lindsay. Is it?
Yes, sir. Just a question, it's sort of born from an earlier discussion we had involving an affidavit. I just sort of want your opinion. Is it within the standard of care, or is it outside the standard of care for a doctor to perform an abortion or any other medical procedure on a patient when you believe that that patient was there as a result of coercion, outside coercion?
I'm thinking, I'm not sure I understand your question.
My question sort of gets to the heart of some of the people's concern here. Is it within the standard of care, or is it outside the standard of care for a doctor to perform a procedure where the doctor, through their counseling with the patient, believes that the patient is requesting the medical procedure as a result of outside coercion?
No doctor would ever do that.
That's what I thought.
That is totally outside the standard of care. It would be unprofessional and unethical as a physician.
Yeah, that's what I thought. Thank you very much, ma'am.
Thank you.
Any further questions? Well, thank you for being with us today.
Thank you.
We have next, I believe, Dr. I think it's either Henry or Harvey Stutter. Please come over. Had you hidden back there, Doctor?
A little bit tight in here.
I know. It's,
Yeah.
appreciate your patience.
Sure. I'm Harry Struthers.
Harry, all right.
So, Mr. Chair and committee members, thank you for allowing me to speak to you today. Again, my name is Harry Struthers. I'm a family physician here in the Atlanta area. I also serve as president-elect of the Georgia Academy of Family Physicians, and we have over 2,500 members in Georgia that represents family physicians, family medicine residents, and medical students. I'd like to begin my testimony by saying I don't perform abortions. However, family physicians are frequently the first physician that a woman talks to when she becomes pregnant. So we're involved by default in that first counseling, what she's going to do. The Georgia Academy of Family Physicians is opposed to Senate Bill 529 as it is currently worded. This bill, if passed, would break down the very essence of the patient-physician relationship. Human relationships are complex, and the relationship between patient and physician is no exception. Professional relationships constitute a particular type of social norm with legal and fiduciary ramifications, some of which you've already talked about a little bit. The relationship between patients and physicians has been analyzed since the 1900s. It's changed over the years. Prior to when medicine was a science, it was mostly an art of you helping the patient with what you could do, which wasn't usually a whole lot. It's about bedside manner. It was about patient and family taking care of what they could. Middle of the century, when technology emerged, some of those interpersonal aspects of health have been overlooked and changed. But there's still some that have stayed constant. There are professional boundaries that are important in relationships in which one party has a greater potential, perceived or real, power and acts to protect the vulnerable participant from exploitation. So again, we have a duty as physicians to care for our patients and look out for their best interests. Indeed, protection of patients from abuses of power has raised the principle of autonomy to so vaulted a place in our society that it's become a guiding value in modern bioethics and medical law. Patients, though, must also communicate expectations to their physicians. This, unfortunately, and especially in these types of situations, is not easy to do. Physicians can't always rely on subtle, unspoken, or supposedly universal understood rules to dictate patients' behavior, particularly in stressful situations. Nor can patients expect physicians to meet unreasonable or unspecified expectations. And because the norms are responsive to societal pressure, we're optimistic in believing that our society is undergoing a sea change that will improve this communication. We've got lots of different cultures in Georgia, people with different backgrounds, and what we expect growing up in Georgia in a relationship is not necessarily the same thing that we see in other people, in other backgrounds. Even within Georgia, you know, my grandmother treated Coles one way, and the neighbor's grandmother treated Coles another way. We look at things in different ways. We hear things in different ways because of our backgrounds. The newest model of physician-patient relationship is the most commonly used in the United States is a mutual participation, which we've tried to talk about, that the physician doesn't direct the patient. The physician has an interaction with the patient and tries to inform the patient about his or her decisions. In this model, we share responsibility for making decisions and the planned course of treatment. The physician and patient are respectful of each other's expectations and values. This bill, as it's currently written, will injure, if not irreparably harm, the relationship between the physician and the patient. The current language would prohibit an open discussion about medical options. The current language, at least as perceived by physicians, and we're not attorneys, and I'm hearing the conversation about law, issues of law, but physicians usually don't go to law school and don't understand those questions. What they're going to hear is this is an intrusion into the patient-physician relationship, and this puts those physicians trying to do their best at risk. So, the Georgia Academy is opposed to coercion in any form. This bill is coercive. It would limit or deny conversations between a physician and patient. So we ask you to vote against Senate Bill 529 as it's currently written. Thank you for your time
Thank
and
you,
your public
Doctor.
service.
Any questions of the doctor? Yes, sir. Mr. Lindsay.
Yeah, sort of building on my question last time. Given the fact, and I assume that you have the same opinion as the previous doctor did regarding coercion, should it not be within the standard of care for a doctor to, as part of their counseling on a medical procedure, determine whether or not there's any kind of outside coercion taking place?
In normal well, I'm not sure that in normal circumstances that's usually an issue in most procedures. I think this is an exception. I mean, most people aren't going to get coerced into having an appendectomy.
Oh, I understand.
So this is clearly outside of normal everyday practice.
Let's bring it into the issue of abortion.
Sure.
Clearly, do you believe, given what the previous doctor stated, and stated very well, and I appreciated it, should it not also be within the standard of care for a doctor who is counseling a patient on abortion to make reasonable inquiries and determine whether or not there's coercion taking place?
I think that rises to a legal question that I can't answer. Partially it comes down to, again, what was presented earlier by the attorney from John Marshall, is to do that assumes, at least for this law, that assumes that there's some reason to believe that there's coercion based upon some protected class. And unless the woman volunteers that their partner is of a different race or there's some other issue, that's not a conversation that's normally going to come up between physician and patient.
Yeah, I'm not looking. I'm looking at purely the issue of coercion in terms of trying to make sure that the patient is there of their own free will.
Like I said, that's not. I think it's easy to answer that if you know that there's coercion, that it's against the standard of care and unethical to proceed. I think, though, it's a leap to say that you should look for coercion in procedures. I think that's a different step. If you know actually that there's coercion, yes, you're responsible for it. I don't know that currently that it would be a standard of care that you inquire in all of your procedures whether there is coercion or not.
Okay. Thank you very much, Doctor.
And we have Ms. Stevenson, I believe.
Thank you, Mr. Chair. Very briefly, isn't it not true, Doctor, that your inquiry speaks to the voluntary nature of the consent?
Yes.
Which is a broad umbrella?
Yes.
Isn't it further true that under that rubric of voluntary that you ask questions after you give the risk in the procedure and that they're there voluntarily?
Generally, yes.
Okay. So under the involuntary nature, would that not cover all aspects of being there, not on your own free will?
I don't know about the legal part of it, but again, you as a physician, you assume, unless you know otherwise, that the patient is there voluntarily. You may see signs. I mean, we do detect people who are victims of spousal abuse and other abuse, and there are signs that you can pick up sometimes with that. So if you have a suspicion, then you would pursue that. But that's not part of a normal informed consent conversation.
Okay, thank
Thank
you.
you. Ms. Dobbs?
Mr. Chairman, my question's been answered. Thank you.
Got that? All right. Well, Doctor, I think that does it with you. Appreciate you being here today with us, and thank you for your time. We've got some others. I'm going to hopefully, we're getting short. We're really past time. Sandra Michaels. Is Sandra Michaels present? There you are, Ms. Michaels. Come on in and
I'll be fast. Georgia Association of Criminal Defense Lawyers. Very briefly, our concern only on the bill is that it's unusually criminalizes the behavior of someone who didn't actually engage in the criminal conduct. So what if the purpose of the bill is to prevent coercing women to have abortions based upon race, color, or gender? It really should be, the crime should be on the person that actually did the coercion, not the doctor. That sort of doesn't make any sense. And on page 2, on lines 56 and 57, where it says unlawful coercion, I'm not sure that's a real definition of coercion. So I think section 1 would be making the person that actually did the coercion the criminal person, and number 2 have a better definition of coercion. And that's
very good.
It's just very overly broad and be very hard to for the people to know exactly what crime they were committing under this, which is not generally what our criminal laws do.
good point. Thank you
Thanks.
for coming here today, Ms. Michaels. Catherine Davis.
I'm going to yield my time, sir, to Susan Swanson and Alex, who drove here from Augusta.
All right. Come forward. And your name is, again, go ahead and introduce yourself, excuse me.
I'm Susan Swanson, and this is Alex. She's going to be sharing her testimony.
Susan Swanson and Alex, all right. Thank you.
I'm Susan Swanson. I'm the director of Augusta Care Pregnancy Center. I've been there 27 years, and I've counseled hundreds and thousands of young women. I've seen many young women, and maybe some of these physicians have not run into the coercion I've seen of all different types. Coercion by boyfriends, husbands, family members. Even this past Saturday, I had a mother who wanted her daughter to have an abortion just because she was embarrassed that her daughter was pregnant at 18. So there is coercion going on by different people. Now, these doctors are wonderful that are here. I don't think they work probably in a freestanding abortion clinic. Most of the girls I've ever talked to who've been in abortion clinics don't see the doctor. They see a counselor beforehand that takes the information, who goes over the information. They never see the doctor until they're laying on the operating table. And then they really don't talk to the doctor. The doctor performs the abortion. They do 50 abortions or more in a day. They're doing them in 10 minutes. They're making $150 to $300 an abortion. So it's a very money-making industry. There's only 2 or 3 doctors who do the 4,000 abortions done in Augusta between 2 clinics, Planned Parenthood and a Women's Preferred Health. We have a center next to both. So I know that this is a money-making industry. It's not like a typical doctor's office where a doctor sits down for 30 minutes or an hour with a patient. So these doctors who have come and represented good doctors that are out there doing their business don't really represent a freestanding abortion service, because these clinics make a lot of money. You can't make that kind of money working in a regular doctor's office. So this is 2 different dynamics that we need to see here. Do the women get due process, like these doctors have said? Do they get true informed consent, or do they just get what the clinic sets up for them to get? And so I have seen pressure from all different types as far as abortion, but I've seen this race issue brought up a lot. We live in the South. I grew up in the South. And I see it a lot with family members who don't want their child to bring a biracial baby home. And so I'd just like Alex to tell her story.
All right, Alex.
I was 14 years old, and I was forced into an abortion because my baby was biracial. I had the choice to either stay at home or get kicked out or have the abortion. I was told that if I didn't go along with the procedure, I would have no place to live. When I went to the clinic, I was never given any other options. I never got to talk to the doctor. The only time I seen the doctor was when I got the medicine and I was laid down on the table. I told the lady that was getting me ready for my procedure that I did not want to do it, and she patted me on my back and told me I was doing the right thing. talk about is
Well, Alex knows the pressure she was under. She knows that even with this child, she was under pressure again for the same reason, a biracial baby. And if she didn't have people who intervened to help her, she wouldn't be able to sit here and her baby's due in the end of May. That's great. But we have to understand, there are young women like this who are not getting due process in clinics. It's different than a local doctor's office where a doctor is able to spend an hour with them. They're not being spent an hour of time with them.
Do I understand, Alex, she did not then go through the abortion?
Oh, when she was 15, she
when
was
I was 14.
14, okay,
yeah,
I'm
she had
sorry.
the abortion. She's now 19.
Okay.
Yes.
I'm sorry. Gotcha.
But she was under pressure with this pregnancy for the same reason, a biracial baby. Don't bring a biracial baby home.
But because I'm legal age to make my own decisions, I chose to walk away.
But she had to leave her house.
Great. Thank you for being here. I appreciate your taking the time to speak. Any questions? Yes, sir. I'm sorry.
You know, I understand what you're saying, but how is that the doctor's fault? That's what I'm trying to understand.
The clinics are not set up as a doctor's office is. These doctors are now, I think,
I'm still here.
The clinics, abortion clinics are doing, like one does 1,500, the other does about 2,000. Those are not set up to spend an hour with a client and go into, because these are basically money-making industries. If they were, they wouldn't make the money they made if they spent an hour with each client.
Right. I understand that, but this bill deals with putting doctors in jail. That's what this bill deals with.
I want to protect this young woman and every young woman that's being pressured to have an abortion, and the doctor needs to give them the due process they would give me. You know, she's having some issues as far as not having money. I have the money. A doctor would tell me all the issues. Sometimes the young women who are not experienced, who don't have the ability to go where they want to go, don't have the choices. So we keep saying girls have choices, but in reality, when the mother is pressuring or the grandmother is pressuring, they didn't have a choice.
And I agree, but we're not locking the mother up that's pressuring her. We're not locking up the person that's causing the pressure. We're locking up the doctor, and that's the part I'm trying to understand.
She was not told. Were you told that there's another option across the street?
No, I was not.
She wasn't told there was another place she could go for help for housing. The whole process, if the doctor is going to have a nurse take the information, the doctor is going to have to hold that person accountable for what information was taken, and he has to be held accountable because it's his license that's on the line.
All right. Thank you. Thank you both. We have one more person, I believe, that signed up, Loretta Grice Cuddio. Did I pronounce that right?
Thank you.
Could
She had to leave as well. She came up from Macon to inform the committee that the Macon chapter of the NAACP also supports the passage of this bill.
All right. I think that completes all the parties who have signed up for the bill. As I mentioned, there would not be action taken today. We wanted to hear testimony. That was the primary reason for the hearing this afternoon. And with that said, we may revisit further hearings on the bill next week. I'll have to find out and announce that, and we'll get word published over our internet site. Thank you for being here today. Committee stands adjourned.